Black Laws, Ninth Edition, Magna Carta. The English charter that King John granted to the barons in 1215 and that Henry III and Edward I later confirmed. It is generally regarded as one of the great common law documents and as the foundation of constitutional liberties. Magna Carta became to be reckoned as the beginning of English statute law. It was printed as the first of the statutes of the realm. When we look into Black Laws, the 9th edition, looking at the word Magna Carta, it states that it was an English charter. Notice that, charter. So I'm going to stop there. There's a lot of people out there that are under the belief that as soon as you come to the word charter, this means or is representing something that is incorporated, something that is a corporate body and therefore is not applicable to men or women, human beings. They like to use that argument when they talk about the Charter of Rights and Freedoms here in Canada. They say, well, it refers to charter, so therefore it only refers to something that is incorporated. However, if you look at the Magna Carta, it also states that it was an English charter. So based upon that reasoning and that logic, I guess you're out of luck. You're using the Magna Carta, but yet it's considered a charter. So it wouldn't be applicable for human beings. But nevertheless, it was an English charter that King John granted. Now notice that here, granted to the barons. For something to be granted, again, this is showing us that it's a sovereign relationship. There's a hierarchy structure. This King John had servants and subjects, him being the sovereign, and he granted to the barons these rights and freedoms that were contained in the Magna Carta. Now, this Magna Carta is generally regarded as a great common law documentation. The expressions in it are regarded as being something that is common law expression and as a foundation of constitutional liberties. A foundation. Now this documentation was brought forth in 1215, basically, hundreds and hundreds of years ago. And at that time, the rights that were enumerated in it, the rights that were given or listed in it to the barons, were something that were new. Something that expressed more liberty than they had before. And it was titled a charter. Now it actually goes on to say that this Magna Carta was the first statute operation of law that became in existence. The Magna Carta, that charter, it came to be reckoned, it came to be noted as the beginning of English statute law. Now notice that description, statute law. We have a charter and we have statute law. And this law was granted to the barons from the sovereign. So we have that whole control mechanism still going on. And this Magna Carta was printed as the first of the statutes of the realm. So that's why it said before that it was considered a constitutional documentation. It's not really a constitutional documentation as we have a constitution nowadays, where ground law, natural law, foundational law is been recognized and placed into this charters, into the constitution that we have nowadays. This constitution, this charter, was statute law that was being brought forth, and it was, again, based upon the structure of a hierarchy operation of law, where you had the king, you had barons, you had men who were serving the king, and were, if you will, in subjection to this sovereign. Feudalism, a land-holding system particularly applying to medieval Europe, in which all are bound to their status in a hierarchy of reciprocal obligations of service and defense. The lord was obligated to give the vassal some land, and protection, and justice. The lord guaranteed the quiet occupation of the land by the vassal, and guaranteed to do right if the vassal became involved in a dispute. In return, the vassal or the lord owed the lord some type of service called tenure. Black Laws, 9th edition. Man, an adult male, humankind, also termed mankind. 3. A human being. 4. In history, a vassal, a vessel, a feudal tenant. Looking at Black Laws, edition number 9. Man, also means human being. And man also means vessel. And this vessel, when we look at it in feudalism, it is bound by status in a hierarchy structure. Again, we're looking at a sovereign, and then underneath the sovereign, vessels. And they are bound by status in this hierarchy structure. So, for example, back in the days, you had knights, you had commons, barons, lords, and so forth. And depending on their status is what rights and freedoms they were allowed to exercise or were granted. Now, this man, this vessel, he had obligations of service. Obligations of service. To who? To the sovereign. And this man owes obligation to the sovereign. Now, this is the same type of structure that is going on presently here in Canada in 2013. There is a sovereign. We know her as the Queen. She has taken that position of sovereign. She has delegated her powers into the Lieutenant Governors and the Governor General of Canada, but nevertheless we have a sovereign. And we are designated, if you will, Canadian citizens, that person, and that person is bound by its status in this hierarchy structure. So for example, if you are just a common person here in Canada, then the police, they have the right, based upon their status in this hierarchy structure, to treat you in certain ways, for example. And judges, lawyers, mayor, for example, they all have different status in this hierarchy system. But their status would be considered higher than the common individual. And again, in Canada, obligations of service. Well, if you've watched my videos, you understand that that person, that incorporated being, that Canadian citizen, is placed into a position where it does indeed have obligations of service to the sovereign through her servants, the public servants of Canada. And that incorporated person, the Canadian citizen, owes obligation and allegiance to the sovereign. So it's very clear that the same system is going on in 2013 that was going on back there in those days. The only difference is they hide it. They try to hide it by changing words and changing definitions. But if you clearly look at it, you see and you understand what's transpiring. Now, this is all important to realize and to learn, because there's a lot of people out there who will define themselves as man and woman. And they'll say, just by taking that title, just by taking that designation, it allows me freedoms and certain rights and that are accorded to me. And they'll state, like, for example, through the Magna Carta. Or through, basically the Magna Carta. Because I claim to be a man, and there were 1 or 2 or 3 freedoms enumerated in the Magna Carta that are still in operation today because of also international law. You find those same Magna Carta rights in the international instruments, those covenants, and then you find them transferred into the Constitution Act of Canada 1982. Plus more. However, those who just stand under the Magna Carta, they only have those few certain rights, and they claim, well, because I'm a man, I have those foundational rights that stem or flow from the Magna Carta, which is true, and it stems on over through international law and into Canada through domestic law. But you're cutting yourself short, because there's a lot more natural law, fundamental law, that have been recognized and granted to us as human beings, as men and women, that you can call on. So you're carrying some freedom, but you're carrying only a couple of quarters, when you could have a whole pocket full of change instead. Now, this man is still, this day, in the laws, this man is considered a vessel under this whole system of hierarchy structure. The only difference is, like we've been saying, is that he has been rendered that incorporated person here in Canada. He has been rendered that Canadian citizen. Now, instead of saying, okay, the man is obligated to these obligations, it's that incorporated person, it's that Canadian citizen that is obligated to these obligations. So that's the difference. However, when you try to go and exercise your freedoms as man, it's difficult to find them. It's difficult to go back and to say, well, the Magna Carta grants me such and such rights, and they stem through law, and therefore I should be allowed such and such freedoms in the courts. They don't really recognize it. Why? Because although you are absolutely right that Magna Carta did grant you certain rights that does free you from the yoke of the incorporated being, the binds of obligations on that incorporated person, those expressions of law were transferred into international law and into constitutional law, especially here in Canada. So you're claiming the right freedoms, you're claiming the right rights, but you're claiming the wrong source. Instead of saying the Magna Carta blah blah grants me such and such and you have to respect, no, it's like, listen, here's the international obligations that Canada as a state party had, here's the fulfillment in the Constitution Act, the Charter of Rights and Freedoms. In that Charter of Rights and Freedoms I find the expression of the Magna Carta, and that's how you link that all together. But this is the system, again, that is still in operation today. As you see, that Canadian citizen, he owes that obligation, and he has obligations of servants to the enactments, to the officers, the public officers, these departments and so forth. They are bound, human beings are bound through their person to the hierarchy status that they've been given or that they operate under. What are we to do with all this junk? Black Law's 9th edition. Fundamental law. The organic law that establishes the governing principles of a nation or state, especially constitutional law, also termed organic law and ground law. It's natural law. Natural law. Verse 2. A philosophical system of legal and moral principles purportedly deriving from a universalized conception of human nature or divine justice rather than from legislative or judicial action. Moral law embodied in principles of right and wrong. Ground law, a fundamental law. See fundamental law. Now listen to the description here. If the power of a sovereign or of a government is limited by a ground law, written or unwritten, a treaty cannot override that constitution. When you look at the Constitution Act, especially here in Canada, or basically in any nation that's under Commonwealth, but I refer more to Canadian because that's where I'm living here in Canada, you got to look at it from the point of view as one individual. You can look at it from the point of view as a unity, as a Canadian citizen, as an incorporated person, and you can see that from that perspective also. But you need to learn how to look at it from an individual perspective, because we learn and we understand that the Charter of Rights and Freedoms, they guarantee us as individuals certain rights and freedoms. And if there are other rights and freedoms that we don't see guaranteed in the Charter, Article 26 allows us then to subsequently call upon those rights and freedoms. Now, the Constitution Act is a constraining power when you're looking at it as an individual. It's a constraining power against the government bodies, against the government officials, not personally to attack the individuals behind these offices, but the powers and the duties that have been charged into these offices. It is the constraining power. It's the rule book that is limiting the power of these government offices. So whether you have individuals who are working in these offices that don't understand the enactments and don't understand the duties, the rights and responsibilities that have been charged into these offices, it doesn't matter. Because the Constitution is that power. It grants you as an individual that constraining power against that office. It's a limiting power against that office. So when you understand how all this is working and transpiring, you'll be able to defend yourself as that individual. Now, the Constitution Act is an expression, it is fully an expression of natural law, fundamental law, and ground law. To trace that back, it's not difficult. Watch some of my videos, you'll begin to understand the expression and what's going on. But the Constitution Act is also an expression of the incorporated system. Incorporated system. So when you look into the Constitution Act of Canada, you see, for example, the designation or the player or the role of an everyone or an individual. And as I shared with you, under my knowledge and understanding that brings forth the capability, the capacity to let the human being enter in. When you bring forth the designation of citizen, for example, it's strictly talking about the incorporated system. That citizen has already been rendered a subject and a servant. So while the Constitution Act is indeed an expression of our natural, fundamental, and ground law, our rights and freedoms as individual human beings existing in this world, on this planet, apart from a sovereign, that's how it's supposed to be, apart from someone claiming, well listen, I have the authority, you're my subject and servant, you have obligations and have to perform services for me. It is kind of ridiculous. I understand that it's necessary in 2013 to some degree, and I agree, for example, with the Criminal Code of Canada, with the parts that deal with common law, that apply to men, that apply to human beings. Without that structure here in our society, we could be running rampant. We look at Mexico, look at other countries. So don't be anti-law completely. That's ridiculous. Someone who thinks like that is not correct. But nevertheless, to force us as human beings, as individuals, to say that we must be part, we must yield, we must subject ourselves to this system that's set up where there's a sovereign who's ruling her subjects through enactments that have been given force of law, it's horrible. And it's totally against all of our natural, fundamental, and ground rights as individuals by doing that, by forcing us to enter into that. And I don't believe that the majority of the government or individuals in government offices are doing that on purpose, because they've never understood that these rights and freedoms are here for us to exercise. The Interpretation Act of Canada. The Interpretation Act of Canada, the Interpretation section. Enactment. Enactment means an act or regulation or any portion of an act or regulation. Interpretation Act of Canada, the Interpretation section. Regulation. Regulation includes an order, regulation, rule, rule of court, form, tariff of costs or fees, letters patent, commissions, warrant, proclamation, bylaw, resolution, or other instrument issued, made, or established. Looking into the Interpretation Act of Canada, and we see that enactment, when you see the word enactment, it means an act or a regulation. Now, some people will say, oh, you see, an enactment, it's an act, it's a statute, it's a regulation. It doesn't apply to me. It's garbage. I don't care about it. It just has to do nothing with me and I'm free, leave me alone, blah, blah, blah. And that's the attitude they take. But the enactment means an act or a regulation. Now you go a little bit further and it says a regulation includes, so they're telling you now, here they're closing it off, includes. Just like we see, where a person includes corporation, well here, a regulation includes, and then they list a whole definition. They say an order, a regulation, a rule of the court, a form, a tariff of costs or fees, a letters patent. Now, some who have followed me and who have gotten to know me understand what that means, letters of patent, but commission, warrant, proclamation, bylaw, resolution, or other instrument issued, made, or established. The international covenants, instrument, issued, made, or established. So, when you say the word enactment, it means an act and a regulation. And regulation includes all of this. All of this. Now, why is this important? Because a regulation is what binds the government. A regulation, again, is that constraining power against the government's actions, if you will, against the offices of the governments. The duties and responsibilities that that office has been charged with is constrained within these regulations, within these operations of law, within the enactments. So some say, oh, the enactments have nothing to do with me, and I don't want to know about them, and I don't care about them. But yet the enactments are where you find these regulations. And these regulations are where it brings forth the right concerning resolutions that are other instruments that are issued and made or established. We know that they're already in the Charter of Rights and Freedoms and Constitution Act of 1982, but nevertheless, if you go looking a bit deeper, we find them now being expressed within the Interpretation Act of Canada. And I'm just going to scroll up here at it, and if you look, the Interpretation Act of Canada was made in 1985. 1985. So we understand, right, that in 1985, Canada was already a signatory to the international covenants. And the natural law, ground law, foundational law, are human rights and fundamental freedoms that were expressed in those covenants. The obligation had now been placed upon Canada to allow their operation within this state party. And in 1982, they brought forth the Charter of Rights and Freedoms, the Constitution Act of 1982, and included our rights and freedoms as individuals in that Constitution Act. Now, in 1985, they make up the Interpretation Act, and they're not stuck, but they also included now in the Interpretation Act those rights and freedoms that are coming down the line. And if you go looking for them, you find them how? They start saying that enactment means an act and a regulation. People back off, individuals back, oh, it's an act, it's a statute, I don't want nothing to do with it. But if you go farther and dig a bit deeper, you see that a regulation includes what? Those constraining powers of those international instruments, of those Charter rights and freedoms. And it comes out because it's in 1985. If they had this regulation, let's say, before 1985, you wouldn't find all these beautiful operations of law available for us as individuals. But because it's transferring down the line, it's beautiful what comes out. That Magna Carta granted men, under that feudal system, remember that always, under that feudal system, certain rights. They were granted by the sovereign. It was still a system of hierarchy, still a system of control. And some of those rights that were granted to men exist today. They're still in operation today. However, those rights were also transferred or recognized in the international covenants and the Universal Declaration of Human Rights and Freedoms. Those original rights. Plus many more. Many more natural rights and freedoms. Many more foundational rights have been recognized. And these rights are recognized by the state party, and they are there for us to operate under them, to express them, to exercise them. It's up to us as individuals.